All right, there we go. All right, it's Steph 30 here with an update on my Chandler court case. I have a court date for my Chandler disorderly conduct case, for whatever they want to refer to it as. I don't know what it is. Well, yeah, I don't know what it is. So, yeah, apparently I got a disorderly conduct case that's been open since June 25th of June 25th, I believe, of 2025. I was arrested for it in a high-risk felony arrest. For some reason, they marked a T-can as a deadly weapon. I hit somebody with a T-can, and they said it was a deadly weapon. They said it happened either on March 24th or March 27th. And I got a high-risk felony arrest happened on April 2nd for whatever reason. Even though it was, they considered it an assault with a deadly weapon, and it was a high-risk arrest. They didn't do it the same day, right? For whatever reason. So, I have a court date set. I had a recusal hearing for the judge, and the recusal got denied. So now I have another hearing scheduled for this Thursday, the 27th of August. I don't even know what the hearing is because there's nothing to hear. The hearing has no point because the prosecution has not sent me any of the discovery at all. Zero. Since last year, I have gotten no discovery. I had attorneys on this case for about 8 months, but at some point in March, they dropped out because they realized I wasn't going to take a plea deal. We'll get into that later. That was the Bayhan Law Group. They just dropped out because they realized I wasn't going to take a plea deal, so they just found a way to run away. So apparently the corruption is that deep here that, the lawyers won't even actually fight your cases if the government wants your head that bad, right? They'll just go in there and they act like they stupid, basically, and then come back to you and say, well, we were able to get a plea deal, and yeah, no, I don't take plea deals for shit I didn't do. Thank you. But anyway, so I filed a motion to continue to the Chandler Municipal Court in the county of Maricopa. I filed a motion to continue, dog. I'm going to read through this motion a little bit, but the reality is, if I'm required to show up on Thursday, this will be the third hearing that I've been required to show up for while I was injured or while recovering from an injury. I was hit by a truck magically on April 28th. It just backed into me at full speed, right? Magically. Because we don't know why they would do something like that. Why they would set up something like that, right? And the police covered up the narrative. So that happened on April 28th. June 25th, 2026, I got T-boned by a huge Chevrolet C30 with a whole load on the back of it, right? That was speeding and hit me while I was exiting an apartment complex. So these are two recent incidents that require recovery from me, like physical recovery. I sent this motion yesterday. I have the transmission receipts. I sent it via email and via a fax app. So they got it via fax and via email. If I'm required to show up on Thursday without any discovery from the prosecutor at all, right? This will be the third time that this judge, Alexa Noel, or however you say her last name, would have had me to show up to court while injured with no discovery. So, that's what I'm saying here, basically in the motion. Grounds for continuance, third forced appearance while injured and without disclosures, right? Also, let me just read through this. The defendant has suffered severe physical trauma from two independent incidents, a tactical vehicle strike on April 28th, 2026, and a major motor vehicle accident on June 25th, 2026, where he was T-boned by a speeding vehicle. Despite filing emergency motions to continue and ADA accommodation notices following these incidents, the court repeatedly failed to issue timely written rulings, forcing an injured litigant to travel to court physically to protect against default warrants, because that's what they really want, because they don't have a case. They really want procedural defaults because they don't have a case. And they're really trying hard to get them too. Like, they're doing all types of shit. They're manufacturing vehicle strikes, accidents, shit in the hospitals, all types of stuff. They trying to get people in the hospitals to inject all types of shit into me, all types of crazy shit. Right? So they're really trying hard to get these procedural defaults because they don't really have a case. The case is fake. But whatever. Also, this judge in this court has failed to rule on any of the motions I filed. So I just been required to show up to court and keep filing motions that never get answered. That's another thing too. They refuse to file any motions, which is how you know they're not acting as a courtroom. They're not acting as a courtroom. They're acting as a human trafficking room. But it's okay. You know what I mean? Let's just keep going. I spit it raw on here. That's just how I just say what it is. I don't really care. And I'm going to continue to. Third compelled appearance without discovery. This upcoming setting marks the third time a pro se defendant will be forced into court while managing physical injuries and lacking basic full Rule 15-1 discovery. The court's ongoing refusal over administrative failure to rule on motions has created an unfair procedural trap where the defendant must repeatedly appear without the evidentiary disclosures necessary to prepare a defense. Breach of the prosecutor's open court discovery commitment. The July 30th of 2026 hearing record. During the hearing on July 30th of 2026 before Judge Scott Silva, that was the recusal hearing that I'm talking about, the prosecutor acknowledged the complete absence of direct discovery and disclosures. On the record, by the way, I have the transcript, so that's how, I can prove it. On the record, the prosecutor committed to contacting the defendant's former counsel, Bayhan Law Group, and explicitly stated that if the files were not transferred to him within a week by the former counsel, that the prosecutor's office would regenerate and send the discovery directly to the defendant in a condensed format. Right? More than a week has elapsed since that hearing, and the state has entirely failed to honor its commitment, leaving the defendant with zero discovery disclosures as the August 27, 2026 hearing approaches. It's 2 days from now. So, I got a prayer for relief where I request that, the third motion to compel the discovery. They need to rule on my motion to compel the discovery. If they're not going to rule on it, then I'm going to file a motion for dismissal. And they're not ruling on any of my motions on purpose because number one, they're trying to aggravate me, but we're going to see who gets aggravated because I make your name mud out here. Also, granting the motion to continue for August 27, 2026, hearing to a date sufficient to allow the defense adequate time to receive and review the disclosures, right? I push the court date back and push it back for enough time for me to get the disclosure and actually review it, because I don't even know why I'm in court right now. And also the third one is imposing appropriate sanctions or precluding undisclosed evidence due to the state's persistent noncompliance. Right? So I sent the motion to continue. I don't play out here. I got transmission receipts. These are the receipts that I sent it, faxed it directly to the prosecutor and directly to the Chandler Municipal Court. See, so I got receipts. I don't play games with mines, right? So we're gonna see what's happening. I'm hoping that they grant this request for continuance. But what's likely gonna happen is, since they're not ruling on any motions at all, and they're just making me come to court without ruling on any motions ever, they're probably not. So we'll be back with an update to see exactly what they decide to do. And then y'all gonna know exactly what I decide to do. I'm out. Y'all have a nice day.